All right, I have Dakota. I know Ms. Martin was going to, she's calling in or doing something. She was just on with my assistant. So let's go ahead with Dakota. We will go on the record in the matters 25 CF 117, 25 TR 650, 651, 652, 653, and 654. State of Wisconsin versus Dakota Mulroy. The state appears through District Attorney Kevin Schmidt in person. Mr. Mulroy appears by video conferencing capability with his counsel, Zachary Fisher, by video. We're set today in these matters for an arraignment and status conferences. Mr. Fisher, were you able to go over the criminal complaint or criminal information with Mr. Mulroy?
Yes, Your Honor, we have received copies of the information. We would waive any further reading. Enter not guilty pleas at this time. We would waive speedy trial and ask to set this for a status conference so that I can review discovery.
All right, not guilty pleas will be entered on his behalf. He is entitled to a jury trial, would be entitled to that speedy trial should he request one. Let's get status conferences. I still don't have Ms. Martin. December 15th at 2:30. December 15th at 2:30. That's your next status block date. We will see you then. Anything else, Mr. Fisher?
No, Your Honor, thank you.
All right, thank you. We are adjourned. Thank you, Mr. Mulroy. Mr. Fisher, I don't know if you want to try and give Ms. Martin a call, but like I said, she was just on the phone with my assistant, but I'm not seeing her on Zoom.
And I did speak with her briefly before court. She told me that she's using a different device, and I guess she doesn't have enough room to download Zoom on that device. So I gave her the phone number to call in to try to call into the Zoom meeting.
That's totally fine. Or, I mean,
Hopefully.
if you want to try and give her a call, she can just call my assistant. My assistant can send her into the courtroom, whatever's easier.
Honestly, that might be easier. I will give her a call and let her know just to call back and see if we can do it that way.
All right, sounds good. I'm going to put the courtroom into the waiting room.
Okay, thank you, Your Honor. I honestly have no clue what's going on, Your Honor. I just spoke with her and she said she was going to call.
It's her responsibility to know how to use Zoom or to test it before, 3 minutes before court. So we will go on the record in the matter 23 CT 74, 24 CM 175, 25 CF 51, State of Wisconsin versus Shannon Martin. The state appears through District Attorney Kevin Schmidt in person. We have Zachary Fisher, defense counsel, by video conference with approval of the court. We do not have Shannon Martin. She was provided with the ability to appear by video conferencing Zoom or by telephone Zoom. She fails to appear. The court will place on the record that I know that she's aware of this. She was on the telephone with my judicial assistant, and she did state to Mr. Martin that she had a new device and perhaps was not able to download Zoom. Mr. Fisher gave her the call-in number for Zoom. The court also instructed that she could call into the judicial assistant and be sent into the courtroom for today's hearing. The responsibility is on the defendant's shoulder to know how to work technology to appear for court at all dates and times. If she fails to appear or unable to appear by video conferencing or by telephone, she must be here in person. She doesn't appear. It is not the responsibility of the court to ensure that the defendant can appear by video conferencing. It is a privilege, not a right. And this is not Zoom court, even though COVID has now made it a lot easier for people to appear for court virtually. It does not give the privilege or the right to have her appear by anything other than in person if she can't get it to work. I do have a message from my assistant right now saying she is now on the phone with her and she's going to send her into the conference room or in the courtroom. I will permit that to happen. She will be reprimanded at that time. Ms. Martin, thank you for gracing the court with your appearance here today.
Hi.
You're late, and I'm going to tell you, I was almost issuing a warrant. It is your responsibility to ensure that you are on time for your court hearings and not to test a new system, not to test a new device 3 minutes before your court hearing. You should have tested it yesterday or as soon as you got the new device. If you just got the new device and you weren't sure if it was going to work, your butt should have been in this chair in the courtroom. You are now 18 minutes, or actually almost 15 minutes late. You're 13 minutes late for your hearing today. Again, it's a privilege to appear by technology and not to be in person. Do not let that happen again. Do not be even 1 minute late to your next hearing. Do you understand?
Yes.
All right, Mr. Fisher, did you go over the criminal information with Ms. Martin?
Yes, Your Honor, we would waive any further reading at this time, enter not guilty plea. We would waive speedy trial and ask to set this for a status conference on that same December 15th day I think we previously selected.
Not guilty pleas will be entered on her behalf. She is entitled to a jury trial. She would be entitled to a speedy trial should she request one. December 15th at 2:30, December 15th at 2:30 for a status conference. Again, Ms. Martin, if you can't get your technology to work, you better be here in person in court. I will not accept even 1 minute late. Again, do you understand?
Yes, I do.
All right, we
Okay.
will see you then. I believe we are in victims' rights compliance, correct?
Yes.
All right. Thank you. Then we are adjourned.
Thank you, Your Honor.